Are you Ariana Evans?
Yes, ma'am.
And this is 22-41163, and Ms. Evans is currently on probation for a lesser offense of terroristic threat against a public servant, a Class A misdemeanor, and previously in court entered pleas of true to counts 2, 3, 4, and 5. I received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, I have.
Are there any additions or corrections?
No, Your Honor.
No, Your Honor.
I have something, Your Honor.
Yes, ma'am.
GPS device, I was just emailed by Friday, 5:43, that it's been dead, the battery's been dead for 3 days.
Okay.
It's not being tracked at this point.
Okay. Thank you, ma'am. Mr. Kimler?
Well, Your Honor, the recommendation obviously is not favorable to Ms. Evans. I mean, they do provide an option that if the court does consider maintaining her own probation.
Well, she doesn't want that.
Sir?
She doesn't want that, right?
What do you want?
I mean, it says right here she just wants to do her time so she can move on with her life and put the case behind her.
Is that accurate?
Yeah, but I mean, if I like get the chance to like get reinstated, I'll do it too.
Which Steve, as far as, what do you want?
If I can do the 60 days that they offer me and be off
Well,
probation.
60 days is off the table. So that's what the state offered, I think, before. Y'all are unagreed. It's up to me to sentence you today.
Yeah,
So,
okay, so
what?
I'll have to be reinstated.
Okay.
It is a misdemeanor, Your Honor.
I understand. Go ahead.
And obviously, the easy way for her to address this situation is to take the revocation and take the guilt out on it. However, the defendant's version does indicate some mental health issues. And obviously, probation is a system designed to try to keep people out of the actual criminal justice system in the future and avoid incarceration. So just looking at this, since it is just a misdemeanor, I would suggest, just in her interest, and perhaps in the interest of the community, that she be continued, follow the, maybe the recommendation, you adjudicate with 30 days up front, or no upfront time, but the mental health component be addressed with Ms. Evans to see if she can make progress with her so-called incorrigible attitude, which I think under the DSM may be diagnosed as an antisocial personality disorder, whatever her issues are from the mental health standpoint.
Did you see that somewhere, or did you just make that up?
Well, I think that if they're saying she's incorrigible, I mean, obviously I'm not a mental health expert.
Okay, I just didn't know, I didn't see anything where she was diagnosed.
She hasn't been diagnosed with that.
Okay.
There's probably some issues there, but
Okay.
obviously things that can be dealt with in therapy.
Judge, I think incorrigible and defiant means she doesn't want to do probation, doesn't like people telling her what she can and can't do. I'd ask that we revoke her.
So, Ms. Evans, I mean, you were given, number one, you were given a great opportunity because you had a felony and they reduced it to a misdemeanor and put you on probation for 2 years. It looks like they gave you all types of help through JCDI, and you failed to complete your groups, didn't obtain a sponsor, you were testing positive, you were ordered to the Franklin North so that you could get some more intense help. You did okay in that, and then you got out and started struggling again. You were also ordered to go to Spindletop for mental health treatment so that you could get the help that Mr. Kimler is saying that you might need. And looks like they say you attempted to circumvent the requirements to obtain a sponsor. Your sister pretended to be your sponsor. You were placed on zero tolerance in JCDI. You tested positive for alcohol. You left the state without permission. I mean, all right, I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of terroristic threat against a public servant. I'm going to sentence you to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you were previously in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You do have some rights to appeal. Y'all need to sign that real quick, please, Mr. Kimler, and give her that bottom copy. And he'll give you that copy of that, and then you can go with the bailiff.
Thank you, Your Honor.
Thank you, ma'am.
Can I get my phone, my sister?
Talk to the bailiff, just talk to the bailiff.
I need to.
Yeah. All right, sir, are you Jerry LeBlanc?
Yes, ma'am.
And Mr. LeBlanc was previously in court, entered a plea of guilty in cause number 21-38605 to the state jail felony offensive theft, and in 22-40408 to the state jail felony offense of abandoning or endangering a child. The agreement in those cases was for a cap of 15 months in the state jail prison. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, sir. Yes, sir.
Are there any additions or corrections?
Not from the state.
No, Your Honor.
All right, Mr. Jeffries, you may proceed.
Your Honor, I believe the most appropriate ending to this is probation. As the PSI report indicates, he would be a low risk on probation. I think just for context, a little bit of history on Mr. LeBlanc. He grew up in foster care. He did get into some trouble in his teenage years into the very early 20s. I believe the last time he got in any trouble, he was 21. He's in his 30s now. It's been 10 years since his last issue, and that was not a major issue that he had. And like I said, he was very youthful at the time. These situations, it's not a situation where he's going to go to prison forever and not come back. He's going to be back in society at some point. And what we ask is that we give him an opportunity to grow. Growth is important, and growth sometimes comes through very troublesome circumstances. In Mr. LeBlanc's case, the child involved in this particular situation has passed due to an illness. And that passing has given him perspective that most of us want nothing to do with. And it's allowed him to reevaluate his life and to see the mistakes that have been made and to grow from it in a way where he's actively contributing to his community. He's volunteering with kids. He's giving up his time and his finances to coach youth football, taking these kids all over the place, trying to teach them the way to do things to prevent them from following the same path that he's taken. Along with that, he does have a 5-year-old daughter that he's very active with, that he has custody of 50% of the time, and he's a strong financial supporter of her. And what we're asking the court to do is to take all that into consideration, along with the fact that the PSI has him indicated as a low risk for probation, and just allow him to continue that growth.
Thank you, Mr. Jeffries. Mr. Smith?
Judge, the child that passed is the child that he left alone in a car in a parking lot at Academy while he and 2 friends went in and stole hundreds and hundreds of dollars worth of stuff, or attempted to steal. He basically says that was his buddies. He wasn't even doing it. They were all obviously working together. They covered the license plate with a rag so that they could make a speedy getaway. They didn't just go in and grab a few things. They had duffel bags full of clothing and items from the Academy. He's been given probation opportunities before and was revoked. His criminal history speaks against him, and I believe I would ask for state jail time in this case.
Thank you, Mr. Smith. So I'm looking back, I'm not sure what has been the delay. These offense dates are from 2021,
Yes, sir.
and it appears that
Both,
August 27th, 2021.
and I believe November of 2022, Routine got 20 months state jail, and then Brooks got probation 2 over 5. That was a cap plea.
Okay.
Your Honor, if I could add just a information. Mr. LeBlanc's position, he understands that he's accountable for this theft. His statements are just an indicator that he did not take any property away from Academy. He knows his cohorts did, and he understands that he's accountable for that.
I guess what I'm looking at is just the length of time. I mean, obviously there's criminal history, and I don't disagree with Mr. Smith, that on paper, this does not look like you should be considered for probation in some ways because of you've been given an opportunity for probation. And just listen. Don't talk yourself out of what I'm about to do. But what I'm trying to say is that those revocations, the one revocation was back in 2014. Obviously, that's a long time ago. You were much younger. You have apparently not been in trouble since the date of these offenses, at least not here that probation discovered. And so you've been out on bond or doing whatever for some amount of time, doing the right thing. I appreciate that you're giving back. I appreciate the things you're doing, and it looks like you've grown up. You've gone through, I understand your child passing away. None of those things, however, makes it okay what you did. All right, so in cause number 21-38605, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offensive theft. I'm going to sentence you to a term of 2 years in the state jail prison, but I'm going to probate that for 5 years. You will be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 22-40408, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of endangering a child, state jail felony. Sentence you to a term of 2 years in the state jail prison, but I'm going to probate that, put you on probation for 5 years. You're also ordered to pay a $500 fine in that case, and you're ordered to follow all of the rules and conditions of probation. Part of those rules and conditions, you are to have no contact whatsoever with the co-defendants, Kendall Pushy and Marquise Brooks. You're also not allowed to go to Academy. And I'm also ordering that you have to find, you're not allowed, I don't know if you're still using medical marijuana. You cannot use that. Because the facts in this case looks like you were doing more than just using medical marijuana. Hang on. When there's scales and stuff involved, that's not somebody that's going to get medical marijuana. And that's what was inside the baby's backpack. All right? Okay. So if you test positive for marijuana, it is a violation of your probation. You will be right back in here facing the 2-year sentence that I gave you today. No negotiation. I just gave you the max, 2 years. Okay? If you follow all of the rules and conditions of probation that you're supposed to, then for all practical purposes, your case here in court is over. You'll be able to serve those 2-year sentences while you're out on probation. But again, the other side of that is if you violate any condition of probation, you'll be brought back here and you'll be facing those 2-year sentences that I just gave you. I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Jeffries.
And there it is, a courtroom moment that speaks louder than any verdict. Not just about broken rules, but about choices, responsibility, and the thin line between a second chance and a final consequence. You can hear it in the judge's tone. This isn't punishment, it's a warning, one that won't come twice. Some listened, some resisted, and some stood on the edge of losing everything. Because in the end, probation isn't freedom, it's trust. And trust, once broken, is hard to rebuild. So the question remains, when given one more chance, will they rise or fall?